Now, some people might label all this discussion right-wing. I don't think it is. Iranian criminal spared deportation so he can cut his son's hair. I think this is the law failing the rest of the citizens of the UK. It really is time for a no-nonsense approach by this government to stop the ridiculous excuses that prevent deportations of foreign criminals from this country who remain here year upon year, even after they've been ordered to leave the country and there's a deportation order to remove them. They remain here for appeal after appeal for many years. Now, the recent white paper did make some proposed changes. For example, for the first time, those that are placed on the sex offenders register will be categorized as a serious crime for the purposes of the Refugee Convention, and thus prohibit them or try to prohibit them from claiming asylum, etc. But that doesn't prevent them from appealing against the deportation order to prevent them from being removed from the country. You may have heard some utterly ridiculous headlines, red headlines I should say, such as this one here that says Iranian criminal spared deportation so he can cut his son's hair. You might read that and think, that's ridiculous, surely. Well, I'll talk to you about it in this video. It's even more ridiculous and insulting than just the headline makes out, as if that wasn't ridiculous enough. Now, I get criticized from time to time. I get called right-wing. I get called grifting on the news to talk to you about these things. But these are absolutely real cases that you deserve to hear about. They do overlap with the law, and you should absolutely hear about them, because otherwise you may never know about them. In fact, some of these cases you may never know about unless they reach the upper tribunal, and the upper tribunal says, no, that's an error of law, and sends it back to the first tier tribunal. More about that in a minute, because there's a complexity there, which again, I think is somewhat insulting, and all the while costing the taxpayer money. Now, putting this in perspective, this is about one individual. There are some 1.2 million that have come here with no right to be here until they come and claim asylum and so on, and over 12,000 this year alone. The reason I talk about this is because A, this is costing the taxpayer money. B, you may not hear about it otherwise unless the news do report about it. Some of them start to report about it now, but you may not fully understand it unless I dive into the tribunal ruling and give you a little bit more information. I can't promise to tell you everything in one short video. That's impossible. I urge you to go and read it yourself if you want the full context and, form a full opinion on these things. And so for that, please do subscribe to the channel. I depend on you to grow. And again, thank you all for subscribing to my other channels, Black Belt Secrets, where you get some more of my personal opinions, and over on my wealth channel, Black Belt Wealth, to help you create wealth. I'm so grateful to you subscribing to those. So let's take a look at this one particular case, and it will highlight to you just how utterly ridiculous this whole system is. Now, one of my major criticisms of the legal system as a whole, which I was quoted in my rather candid interview with the Times in my Times piece, I'm very proud of that. I'll link that below. It's not often I'm proud of things that I've done, but I am proud of that. I like that article. I'll link it below. Go and read it. The journalist did a fantastic job on it, so I'm really grateful. But let's go across to here, because now one of the reasons I said in that article that I think the legal system is outdated and clunky is because of the amount of steps that these cases go through before any kind of actual resolution. This can be the case for the most simple of cases, and there'll be one very shortly in a few short weeks' time. I'll be telling you about one of my own cases. I'll be telling you about that in a few short weeks and why that took so long. But this one, for now, is a fantastic example. Listen to this. Now, this particular case is about an Iranian national who first arrived in the UK in July 2004 and claimed asylum. The reason he claimed asylum was ridiculous, and I'll tell you about that in just a second. And just as a side note, there are a couple of Iranians now stand accused of spying who arrived by small boat. So that answers Jeremy Corbyn's question when he said, how do you know whether people coming from Iran on small boats are here for nefarious purposes? Well, that's how they are accused of doing such things. So let's take a look at this one case here. He first arrived in July 2004 and claimed asylum. He claimed that he was at risk if he was returned to Iran because his girlfriend's parents reported him to the police or the authorities for having sex outside marriage. His claim was refused by the Home Office in August 2004. So his asylum was refused. So he no longer had any reason to be here. He appealed against that decision, and that was dismissed. and that decision was handed out in December 2004. So a few months already have gone by. The adjudicator here did not find him to be a credible witness. The adjudicator found his account to be littered with inconsistencies and concluded that he was not subjected to the ill treatment that he claimed. Rejected his claim that he had a relationship with this girl that places him at risk upon return from either the authorities or the girl's family. She concluded that he would not be at risk of return and dismissed the appeal. Permission to appeal was then refused later on in February 2005. So as you can see, the clock is already ticking. In July 2008, now skipping forward a few years, that's because he disappeared, he was then convicted for possessing false identity documents with a view to gaining pecuniary advantage. Some kind of fraud, document fraud. He was sentenced to 12 months in prison. He was then made the subject of a deportation order. He was notified in August 2008 of his liability to deportation. The Home Office considered that information provided by him, and on November 2008, the deportation order was signed by the Home Office. In November 2008, the Home Office, considered representations that he made, concluded that the expectations set out in the UK Borders Act 2007 do not apply. He was informed that he must now leave the UK, and any appeal may be brought after he's left the UK. So his original asylum claim was refused in August 2004. We're now a few years on, he's been to prison for 12 months, and he's now told in November 2008, 4 years later, that he now has to leave the UK. He then made further submissions, the bit in blue here, I've coloured them so I can refer to them more easily, the bit in blue. He then made further submissions to the Home Office that were considered, and by reference to paragraphs 353 of the immigration rules, etc. In March 2011, a few years on now, the Home Office decided that further submissions made in 2010 do not amount to a fresh claim. Further submissions were then made in April 2011, and in May 2014, so now 10 years after his original asylum claim was refused, the Home Office then refused to revoke the deportation order. So the deportation order still stood, even though, remember, he was told back in 2008 that he must leave the UK, and again later on that he must leave the UK. However, skipping along a little bit further, in April 2019 now, he provided another statement with another claim, now saying that he'd be at risk if he returned to Iran because he'd been criticising Iran whilst he was in the UK. That was supported by yet another statement in September 2020 with further submissions from his representatives, Freedom Solicitors, and that was dated September 2020 and April 2022. So this fresh argument, not that it was a valid argument, but this fresh argument spanned those 3 years after he'd already been told to leave several times. In October 2022, the Home Office then made a decision to refuse his protection and human rights claims for the purposes just explained, and he was informed that he does not qualify for leave to remain in the UK on any basis and concluded that there are no grounds to which to revoke the deportation order. So the deportation order was still valid, as it had been valid for many years, but that was not quite yet the end of the story, because he came back for yet a further bite of the cherry. This time, he was successful. This time, his appeal against that decision was allowed on human rights grounds by a first-tier tribunal judge. That decision set out in August 2023, almost 20 years after his initial asylum claim failed. However, it's the reasoning that was successful which is really the nub of this video. So let me skip down to a little bit here. So the bit in orange and the bit in yellow. So his argument in a nutshell, even though he didn't live with his son, that it would be unduly harsh for his son if this guy was deported, mainly because he played with him and cut his hair. Word for word, that's what is written in this judgment here. This judgment I'm reading now, you understand, is the later appeal where the upper tribunal said, no, that's not good enough and sent it back to the first tier tribunal. So what I'm about to read has now been rejected, but this was allowed the first time around, which is why he's still here. The judge, the first tier tribunal, accepted the evidence that most of the time they spend together is playing because of his age. The oral evidence of this guy was that he cuts his son's hair. The judge acknowledged that relationships such as play and this sort of relationship would be most important to a young child cannot be satisfied remotely. nor can cutting his hair be done remotely. And now the bit in yellow, the judge set out the reasons allowing the appeal on the Article 8 grounds for the reasons just set out. And the judge said it would be impossible for his partner to visit him in Iran with the child. The relationship might be able to continue in some form through modern means of communication, but would be more limited in scope than the relationship in its current form. That he had demonstrated a commitment to the relationship. He sees his son every day, takes him out to give his mother a break, and plays with him and cuts his hair. His aspirations for the relationship, he wants to teach his son Kurdish, etc., etc. And if he were to be deported, his son would lose all possibility of the playing and the cutting of the hair. More importantly, he would lose having a second adult in his life to provide love, affection, and understanding. And ultimately decided that it would be unduly harsh to deport him, and so let him stay. But the upper tribunal disagreed, and that's why we get to find out about it now, because case law has decided that unduly harsh has a different meaning. Unduly harsh does not equate with uncomfortable, inconvenient, undesirable, or merely difficult. Rather, it poses a considerably more elevated threshold. Harsh in this context denotes something severe or bleak. And furthermore, the adverb unduly raises an already elevated standard still higher. So it's unduly harsh. So it has to be a really severe and high threshold to meet. The upper tribunal just didn't accept that. In fact, the upper tribunal emphasized the fact that it's in the child's best interest to have both parents with him in the UK is not a trump card. And thus the judge of the upper tribunal said, I'm satisfied therefore that this is one of the appeals to the upper tribunal which the judge has failed to give adequate reasons for the finding of the effect of his deportation would be unduly harsh. The reasons given do not demonstrate the judge had applied the relevant test and had in mind the elevated threshold. Therefore, this is set aside for a material error of law. But in fairness to this guy, it's now been remitted back to the first tier tribunal for a rehearing for his Article 8 claim. Largely because the judge did not go on to consider the very compelling circumstances, and it is of course necessary for the first tier tribunal to give directions in the appeal and case management and so on. So now it's going back yet again to the first tier tribunal, having been almost 20 years after his first asylum claim failed. All of this costs money, all of this takes time, and this is just one individual. Now there's nothing in here about how he arrived. It may have been by a boat, it may not have been, but the point is, over 12,000 people have arrived this year alone, and there's something in the region of 1.2 million here, each of whom might make a similar claim to this, each of which might be equally ridiculous, and each of which might take 20 years, as this one has here. So just to recap, he arrived in July 2004 and claimed asylum. He was refused in August 2004, and we are now 2025, and this has just been handed down in March 2025. All the way along, he's been told that his asylum failed. He was subject to a deportation because he went to prison, and presumably he had no right to be here anyway because his asylum claim failed. I don't know whether he was on any visa, but there's a missing gap of a few years, at which point he was then convicted in the magistrate's court and sent to prison for 12 months for some sort of document fraud, and then all of the deportation procedure followed. But here we are. That was in 2008. In August 2008, he was told that he was being deported, and he's still here. So there we are. Now, some people might label all this discussion right-wing. I don't think it is. I think this is the law failing the rest of the citizens of the UK, because this guy was not supposed to be here. And more than that, he was deported. He was ordered to be removed from the country, and yet he's still here. That's the problem, and that's why I tell you these things in great detail. So when you see these headlines, sometimes they might not be completely accurate. Sometimes I might not be completely accurate, but I'll hold my hands up to that if that's the case and be pointed out where it's changed or whatever. But these headlines, by and large, are true because they do look at these tribunal rulings because that's how they find out about them. Because these ones tend to be published. They're not all published, just like small claims cases at the county court. They're not all published unless you ask for a written judgment and you get one, or the judge decides to give one because it's a specific case. For example, we've had the Ring doorbell case. I did a very lengthy video on that because a circuit judge decided that she was going to take this case and do a full judgment on it so people knew exactly where they stand via the harassment and breach of data protection laws when you're using a Ring doorbell. That was a very detailed video I did of that because we got the judgment. We don't always get these judgments, but I hope you find it useful. Please do subscribe to the channel, and I'll see you in the next one.